The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. Good morning. Welcome to the Fourth Circuit. Ready to hear argument in our first case, United States versus Jones. Ms. Ray.
Excuse me. Good morning, Your Honors. May it please the court. Amy Ray for the United States. Your Honors, the district court erred when the court applied the safety valve to Ms. Jones because the best reading of that provision to avoid surplusage and to avoid a result that simply doesn't make sense is to interpret does not have to apply to all three of the recidivist possibilities. So does not have more than 4 criminal history points, does not have a prior 3-point offense, and does not have a prior 2-point violent offense.
So and does not mean and in the statute here.
Your Honor, we certainly think that and does mean and, but it means and in a distributive reading. So does not have and does not have.
That's just a fancy way of saying and means or.
It certainly could have been written as or. And so the question is, I would say this, we have 2 plausible readings of this statute. Both are plausible, that's why we're here. What then is plausible about the rest of it? So if we have the language.
Counsel, I'm sorry, can I just ask, if we have 2 plausible readings of this statute, is there room for the rule of lenity here?
Only, Your Honor, if there's grievous ambiguity. And we would suggest that there is not, and I would note that none of the 5 circuits who have decided this issue have actually applied the rule of lenity.
Although there are several judges who have said, 2 courts, right, who have said, if I thought it were close, then I would go with the rule of lenity.
That's true. That's true. But nobody, after looking at everything, the language, the context, the purpose, none of the courts have, the majorities of any court have reached the rule of lenity and relied on it.
But if we conclude that and means and Congress meant what it said, there isn't any ambiguity.
Your Honor, there is ambiguity in the sense that I think that there are 2 ways we can read this. We agree that and means and.
Well, if we conclude that and means and we look at the rest of this particular statute where Congress appears to know how to use or when it wants and when it wants, that makes it more difficult, I would think, to say that we should pick one subsection of the statute and read the term and differently than we would read it in all the other subsections.
Well, so I understand that, Your Honor. I would say that there is Judge Oldham in Palomares, in her concurrence, offered an alternative way of reading it with and that I think is also consistent and not ambiguous. So
we've got colleagues across the country who've given us any number of ways to look at this.
It's true. It's true. And I'm in the same position that Your Honors are in terms of just wrestling with this statute and trying to figure out what is clear and what is not clear. What I do know is that the rule against surplusage is a powerful canon. I also know that the safety valve, the purpose of the safety valve is to enable nonviolent, low-level offenders to benefit from it. It is not to enable.
So can I ask about, I get that point. And one of the arguments I suppose you have is that reading it the way Jones would have it read would lead to absurd results, right? That's one of your points among many. But is it really absurd when ultimately it's up to the district court judge to decide whether or not to apply the safety valve? In the end, that's sort of the safety valve to the safety valve, because ultimately, if a district court agrees with you that in a particular context it just doesn't make sense to apply it, notwithstanding what some judges have considered to be the literal interpretation of the statute, that's where those things can be hashed out.
That's right, Your Honor, but I would say this in response to that observation, that while it ultimately is up to the district court's discretion, the mandatory minimums are powerful. And it simply does not make sense for a defendant in this very odd category of having.
Well, they are powerful, but it's clear that Congress intended to allow district courts to deviate when appropriate, right?
That's right. That's right.
But why don't we just trust our district court colleagues to get it right?
It's not a question of getting it right or wrong. I mean, we have to say, what is the best interpretation of this statute? Yes, it's ultimately a discretionary call, but it's a discretionary call when that allows everyone to take advantage of it, except this very odd group of folks who have a 2-point violent offense, a 3-point offense, and 4. So unless somebody has all 3, and that's completely. It just makes absolutely no sense.
Well, there's a lot of things Congress does that some of us
Sure.
might think don't make a whole lot of sense.
Fair enough, Judge Agee. But when there is a reasonable construction that yields a sensible result and one that accords with the purpose of the statute, and so what I was talking about with respect to the Judge Oldham's interpretation, which I actually thought was interesting, and not simply because it yielded the result I wanted to, although admittedly that was a happy circumstance. But what it showed, what Judge Oldham talked about was, if you look at the structure of the statute, it actually begins with the district court must find with an M dash, right? M dash, and then you have the subsection 1, which is the only subsection that deals with recidivism. And it says does not have M dash. When you talk about the first part where it says the district court must find M dash, this court and all others have construed that to mean that all of the 5 provisions that follow must be satisfied for a defendant to receive the safety valve. So by construing what follows the M dash with an and to mean that, that basically you have to have all of this or you don't get it. And in this case, it's does not have, then does not have applies to all 3. So in the first case, the court must find applies.
Seems like an awfully convoluted way for Congress to have written a statute which, if it intended to say what you have proffered to us is the meaning, it simply could have used or, and you wouldn't have that problem. Or
True.
to have written it,
Yeah.
a defendant shall not be eligible if they do any of the following 3. It just seems very odd, even for Congress, to have written a statute like this.
I think that when you have a court must find and then you have the M dash and every single thing the court must find applies to all of those 5 things. The court must find that the recidivist, the court must find that they're not a supervisor or manager, that it applies to all of that, then why wouldn't does not have that precedes an M dash also apply to the following 3? I agree with Your Honor, there are simpler ways to say it, but without that construction, we take subparagraph A completely out.
Well, a bunch of judges, right, and courts have come up with plausible work that A might be doing, even on the disjunctive reading. And I guess one of my questions is, whether at the end of the day you would hold that those theories are correct or not. I mean, isn't the fact that there are plausible accounts of the work that A might be doing, isn't that sufficient?
Your Honor, I think if those accounts were faithful to the language, maybe, but they're not, because they basically read out according to the sentencing guidelines. If you read the safety valve provision F1, and it says with respect to each of these, a 1-point offense as determined under the sentencing guidelines.
Is this about the Lopez court's theory about what C means?
Well, also, no, it's actually about Judge Pryor's decision in Garcon and what he says, which is essentially that
He ties the statute directly into the guidelines language and gives 2 examples of how the 2-point offense and then the 3-point offense come up with points, but they're not criminal history points because of the passage of time.
Right, so
Is he wrong?
he is wrong because he's not wrong about the way that 2A 1.2 applies. Obviously, he's certainly right about that. But what I would say that Judge Pryor gets wrong there is that when Congress, what he basically says is Congress came up with new language when it talked about 2-point offense and 3-point offense. That's unique to this statute. But that makes less sense than the notion that Congress was giving a shorthand way of saying, what's a 2-point offense? We know it's 4A 1.2, sorry, in 4A 1.1 is no, I'm getting that wrong, aren't I? I got it right. 4A 1.1 defines what a 2-point offense is, what a 3-point offense is, and what a 1-point offense is. And you stop there because that's the language of the safety valve. And you don't go to 4A 1.2 in terms of how you apply, what points get actually counted. That's a counting provision. That's not a definitional. That's counting.
Can I ask you a question? And I'm struggling with exactly how to frame this, about this surplusage thing. It just seems to me that we have a case where the text is really clear. And so the surplusage maybe would have to be incredibly obvious to kind of counterbalance that. And I just feel like, first of all, even from a kind of a standing start, it's not particularly obvious. Like I could imagine Congress just passing this statute and not sort of catching the addition problem that you're presenting. And then on top of that, we have at least plausible accounts for how there might be a difference between the points under A and the offenses under B and C. And when you add that all together, I'm just sort of struggling to see how in this particular case the canon could override the text.
If the text were as clear as Your Honor suggests, then the canon wouldn't override the text. But the text isn't that clear.
So you're starting from the proposition that the text is kind of like hopelessly ambiguous, so let's go with the canon.
That's right.
Okay.
And the canon, as well as what is the best way of achieving the purpose of the safety valve. And it probably was not to allow a judge to have discretion when someone had three-point violent offenses.
Counsel, there are going to be anomalies either way, right? When Congress passes a general statute, there will be cases that don't seem like they're what Congress had in mind. And I'm thinking of the graffiti defendant in Lopez, not a violent offender, one graffiti offense. Congress probably, as far as we can tell, Congress probably thought it would be fine if he could at least have a chance at being sentenced under the mandatory minimum. And I guess I'm sort of circling back to where Judge Diaz was, that if you use the conjunctive construction, the district court judge's discretion takes care of the anomalies. If we adopt a disjunctive construction, we're stuck with the anomalies. There's no way out.
Except that, Your Honor, I don't think that Congress would have intended. What is the purpose of this provision if it yields only a very tiny category of defendants who don't get it?
Well, that's a policy argument, isn't it? It seems like you're back to your absurdity argument. And
Yeah.
absurdity is a pretty high level to reach. And as Judge Harris indicated, there are some plausible readings, but even the Supreme Court has said, that if the text is clear, we were to conclude that, then if there's surplusage, then it's up to Congress to fix it.
Your Honor, this court in Sims said that this court cannot reach an interpretation that yields surplusage of a
The
significant.
Supreme Court says that you can.
I don't know of any case where the Supreme Court has found that surplusage is okay when it's a significant part of the statute, not just sort of one little, this is one of three categories that either places someone that would prohibit someone from being able to take advantage of the safety valve, depending on whether you have to show, the government would have to simply show one, it's the defendant's burden, but whether one disqualifies or whether it's all three. So
Go back to the Judge Harris's earlier question about the rule of lenity. This case has a lot of interesting parts, including math, apparently, which It's always a perilous endeavor for judges. And I haven't counted up the number of judges who are on either side of this argument, but is it the very fact that we have so many judges disagreeing with each other about what the statute means, by definition suggests that this is in fact a grievous ambiguity, in which case we fall back to the rule of lenity?
No, Your Honor. At the end of the day, what the Supreme Court has said is that the rule of lenity applies essentially when you just have to guess. And no judge that has looked at this in terms of no court, the majority has looked at this and found that there was no way to answer this question. They've disagreed about the answer, but
I mean, again, I think I'm remembering right. That is true only because at least the 11th Circuit and the 9th Circuit ultimately found that the meaning was clear in the defendant's favor. But both of those courts were very clear that if there were any question about that, then at best, this was grievously ambiguous. At best, from the government's perspective, this is grievously ambiguous, and they would apply the rule of lenity.
Your Honor, I see that my time is up. May I?
Please.
So it's true, but part of my point is that everyone has ultimately decided one way or the other that the statute was sufficiently clear not to apply the rule of lenity. And I think that what that says, Judge Harris, is how grievously ambiguous it has to be. And our interpretation we would submit is a very plausible interpretation of the language, and it accords best with the statutory canon against surplusage, and most importantly, with the purpose of the statute. Their interpretation, the defendant's interpretation, does not achieve that purpose. Thank you, Your Honors.
All right, you've got some rebuttal time, Ms. Ray. Mr. Carpenter, maybe you can make this very clear.
May it please the court. The government is asking this court to engage in grammatical gymnastics to achieve a statutory meaning that Congress could have achieved, as you've noted, by simply replacing the word "and" with the word "or." We are asking this court to reject that interpretation and affirm the sentence below.
So would you simply say the statute means and that's the end of the discussion?
Yes. I mean, I think that as Judge Pryor does in the Garcon case, of course, the court should go forward and address the government's counter-arguments, right? So I do think it's worth addressing surplusage and worth addressing absurdity. But I think at the end of the day, I would make the point that Judge Newsom makes in his concurrence in that case, which is that no amount of canons can convert "and" into "or." So the plain language "and" means "and," that answers the question. You can address, you can explain the surplusage, address them in the opinion, but I don't think they can be used to inject ambiguity into a statute that is otherwise clear. And I think I want to just highlight the key point, and I think you've touched on it, that I think undermines the government's argument. And that is there are three very simple, very clear ways in which Congress could have written this statute to achieve the meaning that the government wants. First, as we've talked about, it could have used the word "or" as it did in all of these other provisions of the safety valve. Second is it could have used a word like any of the following before the M- as it did in other provisions of the First Step Act. And the third thing it could have done is it could have repeated the verb phrase "does not have" in each subsection, as it did in F4, where it repeated the verb phrase "was not" before the two criteria in that provision. Each of those constructions were available to Congress. They used them in related provisions. And it's implausible to think that with those constructions available, that Congress intended instead to use an M-, hoping that the reader would know that that M- distributes the prefatory clause into each of the subsections. It's implausible to think Congress would have done that because there's no Supreme Court case that says an M- works that way. There's no treatise on statutory interpretation, no dictionary, no style guide, no drafting manual, no authority of any kind that suggests M- work that way. The other thing I would point out about the M- that I do think is important is the canon of consistent usage works against it, as Judge Willett explained in his dissent in the Fifth Circuit. I know my friend relied to some extent on the presence of the M- in the beginning of 3553F, which leads into the 5 separate criteria. But that M dash, under their reading, isn't distributive. It doesn't work the same way as the one in F1. Because if the M dash distributed the prefatory clause, so the prefatory clause in F says the district court has authority to go below the mandatory minimum if it finds X plus Y plus Z, 1, 2, 3, 4, 5. If instead this has a distributive reading, instead of one grant of authority based on these 5 criteria, there would be 5 separate grants of authority saying the district court has authority if it finds the lack of criminal history points. The district court separately would have authority if it finds F2, and separately would have authority if it would find F3. In other words, and Judge Willett explains this better than I am doing in his dissent, it would convert a 1 grant of authority with 5 criteria into 5 separate grants of authority, where a defendant would only have to satisfy one of these 5 things to be safety valve eligible. It's yet another reason not to follow the government's interpretation. I'm happy to talk about the surplusage or absurdity arguments if the court wants to. At the same time, I also recognize you have other business to get to, so if there...
Can I just ask you about, Ms. Ray at one point mentioned that the reason why this, in her view, in the government's view, just doesn't make any sense, is that it really just cabins exclusion of the safety valve to a very narrow set of people with a, for lack of a better term, particular set of skills in terms of their ability to accumulate criminal history points and the like. It just doesn't seem intuitive to think that Congress intended that result. How do you respond to that?
So first and foremost, what I would rely on is the Lopez case that we cited in the briefing. If the statute is ultimately interpreted the way that Lopez interprets it, it's not actually a particularly odd combination of criminal history that would disqualify someone. And the reason for that is, the reason the government has this argument that it's a peculiar combination is that the 2-point violent offense would, in their view, exclude a serious violent offense, which, as the Lopez court explains, doesn't make a whole lot of sense, that Congress would have set out subsection C to target only minor or medium, I would say, violent offenses while not caring about more serious ones. So I think under the Lopez reading, the combination isn't actually all that unusual. But that said, even if it were an unusual combination, the point I would make is the one that Judge Pryor made in his opinion, which is that Congress legislates broadly and there's always going to be marginal cases. As long as we can say that it could be rational for them to do it, that's good enough. In other words, absurdity is a very high bar, especially a high bar to overcome plain language. And on that point, I think I would reiterate what Judge Willett says in his dissent in the Fifth Circuit, which is that the absurdity doctrine really has no place in a criminal case where it should be trumped by the rule of lenity. And he cites the Wiltberger case from the Supreme Court for that proposition, where the language was plain, seemed kind of nonsensical, and yet the Supreme Court said, this is a criminal case, we can't construe the language against the defendant in the way that the government sought in that case. So I think that's an important point on the role of lenity with respect to the absurdity arguments that the government makes. If there are other questions, I'm happy to answer them. Otherwise, I ask the court to affirm the decision below.
All right, thank you, Mr. Carpenter. Ms. Ray?
Thank you, Your Honor. I won't say much unless Your Honors have additional questions. I will say that the Lopez interpretation of interpreting subparagraph C to mean at least 2 points does more violence to the language of the statute than the government's proposed interpretation.
Can I say, what if I thought, let me just ask you a hypothetical. What if I thought they did equal damage to the text of the statute? Then, under the rule of lenity, shouldn't I adopt the Ninth Circuit's Lopez reading? If I have to do one or the other to make this statute make sense, I thought that was also one of Judge Willett's points in dissent that I found kind of compelling.
Your Honor, I don't think so, because I think at the end of the day, and I want to make clear that it's not just the absurdity, it's both that and the surplusage issue, and the fact that we think we do have a consistent reading of "and" in this statute.
But am I right that on the Ninth Circuit's reading of subsection C, we get rid of both surplusage and absurdity? If it means at least 2 points, There's nothing absurd about the statute, and also A is still doing work.
If it means at least 2 points, I think that it still would be, I'm trying to think about whether or not that's actually, whether that achieves the objective. And even so, you'd have somebody who has a 3-point, I think all it does is really gets rid of surplusage. I don't think it does any.
Seems like a lot of the absurdity arguments floating around, and I'm sorry, I don't remember which ones are in your brief and which are in all of these other cases.
Sure.
But a lot of them do depend on this idea that someone can have a whole string of 3-point violent offenses and not be covered.
Or lots of drug offenses and no violent offenses. It makes in fact, it has to be medium level violent offenses. But if you read it the way that the Ninth Circuit does, I suppose then the folks who could not take advantage of it would be those who have any medium or high level violent offense, as long as they also have, well, it'd have to be 2 or 3. So, yeah. But I think that interpretation requires this court to add language, and the government's interpretation does not require that. If your honors have no further questions, the government requests that this court vacate the defendant's sentence and remand for resentencing. Thank you.
All right, well, we thank both counsel for their arguments in this case. It's always possible Congress might clarify this. I don't think I'd hold my breath. Or it could be somebody's ticket to the Supreme Court. So, as you know, we usually come down and shake your hands pre-COVID, but we're still COVID restricted, so we wish you the best, and we'll now move on to our next case. So our next case is No Mid-Currituck Bridge versus North Carolina Department of Transportation. Ms. Hunter, whenever you're ready.
Thank you, Your Honor. May it please the court, I'm Kim Hunter with the Southern Environmental Law Center representing the plaintiffs, and I have Nick Torrey and Hannah Nelson with me at council table. Your Honor, the central issue before this court is this. If the government does not provide the public with relevant information at a meaningful time, then the National Environmental Policy Act cannot perform its role as a democratic decision-making tool. In this case, the transportation agencies failed to provide the public with relevant information about the Mid-Currituck Bridge in 2 distinct ways, both of which stand in sharp contrast to what this court has long made clear that NEPA requires. First, the transportation agencies failed to provide the public with over 7 years of new information about traffic forecasts, population growth, project costs, and sea level rise. And all of these issues have significant implications for a decision about whether a destructive 5-mile, $600 million bridge is the best transportation solution for a barrier island on North Carolina's Outer Banks. Second, in a direct rebuke to this court's prior precedent, the transportation agencies failed to disclose the indirect impacts the bridge would have on the natural resources of the Outer Banks. And this failure came about because the agencies relied on population and traffic data that assumed the bridge would be constructed to create the baseline condition. This is an error that these same agencies have made multiple times before, and one that has been squarely rejected by this court. Both of these errors are independent violations of NEPA, and either of which is sufficient to invalidate the record of decision here. This court should vacate the record of decision, and if the transportation agencies wish to proceed with this bridge, they should be required to prepare an up-to-date supplemental environmental impact statement for full public review that accurately discloses the impacts of the bridge and its relative merit with regard to other alternative solutions. And I can discuss each of these claims in turn, Your Honors. So with regard to the 7 years of information which was not provided to the public, CEQ regulations require that, quote, when there are significant new circumstances or information that are relevant to environmental concerns and have a bearing on the proposed action or its impacts, a supplemental EIS must be required.
What do you say that the agency should have done that they didn't do here?
Could you repeat the question, Your Honor?
What do you say the agency should have done that it did not do here?
Yes, Your Honor. I would say there are 3 main things. First of all, the agency should have taken a hard look at that significant information. And in certain circumstances, it did take a hard look at traffic forecasts, for example. But in other circumstances, like sea level rise, the agency didn't even do that first step that this court, of the test this court has articulated in Hughes.
Are you talking about the information that your client sent them or something else?
Both, Your Honor. The agency has a responsibility to look at information we sent them, but they also have a responsibility just to look at relevant information. For example, if you're building a bridge to a coastal barrier island, you have a responsibility to look at sea level rise data. So that was the first error.
They did look at sea level rise.
The agencies looked at some, they looked in their reevaluation, they looked at some still slightly outdated sea level rise data, but they did not look at the most up-to-date sea level rise data that had been put out into the public by the Federal Highways sister agency, NOAA. But I would say more importantly than that, this isn't really a question of...
The agency says a lot of that data wasn't really specific to this location and that it was sort of generalized worldwide data.
Well, in fact, what the agency didn't look at was that more specific. They looked at some generalized data, but I would make the point that this question of which particular sea level rise data they looked at is really beside the point. That is an error, but the more fundamental...
Why is it beside the point, though? I mean, if you're sending them sea level rise levels off the coast of India, how is that relevant to sea level rise on the barrier islands of North Carolina?
It wouldn't be, Your Honor. And the sea level rise data that they failed to look at was specific to Duck, North Carolina. But regardless of that particular question, I think...
Wait a minute. So tell us exactly where we're going to find in the record that particular piece of information.
Yes, Your Honor. Well, let's... The fourth assessment sea level rise data is referenced in the record at JA 01945. And the duck projections, which we referenced, are in the record at JA 03677. But if I could make the more fundamental point here, Your Honor, it's not a question of did they look at precisely the right sea level rise data. The question is, did they ever actually analyze how sea level rise would affect this bridge, and did they disclose that information to the public? Because the last time the agencies performed the mandated public review of the Mid-Currituck Bridge was in 2012. And at that time, sea level rise was not as much of a problem as we know it is today. And when the agencies did that public analysis, what they disclosed was There'll be at most 26 inches of sea level rise, but we don't need to worry about it because the bridge will be long past its usable lifetime then. And so we're just not going to be concerned about this.
Why doesn't that make sense?
That made sense in 2012. What's happened since then is the projections of sea level rise have increased significantly. And so now you have a level of sea level
Well, but the agency,
rise.
as I understand the record, indicated that these new forecasts that I think you're talking about were within the range originally considered. So is that incorrect as a matter of fact?
It's incorrect as a matter of fact, and it's also incorrect because the period of the usable lifetime of the bridge has changed over time. So what they looked at in 2012, they said, well, even though we're sort of going to take this cursory look at 26 inches, we're not going to really analyze it because the bridge won't be usable by then. But now, when we're going to see a much higher level of sea level rise a lot earlier, which is actually going to inundate roads going to the bridge, that information about that level of sea level rise is much more relevant. And that is, there is nowhere in the record, is there any public review that has been presented to the public prior to this decision being made, which gets to that question of, if the sea levels rise and these roads start to be inundated, is this bridge still the best transportation solution for the Outer Banks? And that is the question.
Maybe I'm wrong about this, but I thought the agency concluded that with a rise in sea level, that made the bridge all the more important because it was the one secure location by which you could exit the Outer Banks.
I wouldn't say, Your Honor, that the agencies concluded that. They did put a throwaway line in their final EIS, but this bridge as the only causeway off the Outer Banks has never been a purpose for this bridge. And when you're analyzing
If I was on the
NEPA,
Outer Banks and the sea level was going up and I needed to get off, I'd think that'd be pretty important.
absolutely, Your Honor, and if the agencies want to design a bridge for that purpose, they can establish a purpose and need, which is sea levels are rising, we need a way off this island, what's the best way? And then they can analyze solutions, present that to the public, and that would follow what NEPA requires. But that's not what they did here. It was never a purpose of this bridge to be the only causeway off the Outer Banks.
Can I ask you a question, sort of backing up a little bit? The sea level rise and the changes in the traffic data, they don't affect the environmental impact of building the bridge, right? And the district court thought doesn't affect the impact of the bridge itself, then there's no need for a supplemental impact statement. And you say that's wrong, obviously. But I mean, I'm looking at the regulations for the Highway Administration, and they do seem to say that you have to do one when there's new information relevant to environmental concerns bearing on the proposed action. Or its impacts would result in significant environmental impacts not evaluated in the EIS. So you're under relevant to environmental concerns.
That's right, Your Honor, and it's
what-
relevant to environmental concerns
right.
whether you build a destructive bridge or you upgrade existing roads. And so if that's still a question 7 years later and there are new
So
circumstances.
your premise is anything that might change sort of the balance and make the agency pick something that is less environmentally damaging is going to be covered.
That's right,
Is
Your
there
Honor,
any
and
limiting
that's,
principle there? Because that seems like there'll never be a final environmental impact statement if that's the standard.
yes, Your Honor. Well, first of all, I think as the Supreme Court said in Marsh, it has to be information that is helpful to the decision-making process. So, just some.
Marsh was a case, right, where it was a direct environmental impact.
It was, but there's a longer discussion in Marsh about sort of general NEPA principles and why we continue this analysis throughout the process, because NEPA is this action-forcing device which, helps the government make these better
But
decisions.
what is the limiting principle, though, in
So-
Judge Harris's question? Because when you have a delay, and here the delay arguably is getting close to 50 years, every year that goes by, the economy's going to change, other things are going to change, and I thought I read several places in the district court's opinions where the plaintiffs had conceded that there was no change in the environmental impact with respect to the bridge, but that your arguments went more to financial aspects and that sort of thing, not environmental matters.
Well, Your Honor, if I can answer the limiting principle first, I think one big limiting principle here is the decision had not yet been made. So this isn't a situation where final decisions been made. And also, the agencies were already triggered to do this reevaluation, which they're required to do internally if 3 years have passed. So there are limiting principles in place, and the question is, when they did that reevaluation, which they were required to do by law, were they correct in concluding that nothing was significant?
I'm sorry, I got tripped up in reading this regulation, but I'm sort of focused on this. It does seem as though the Highway Administration regulation requires a supplemental impact statement only when this new information bearing on the proposed action would result in significant environmental impacts not evaluated in the EIS. Do you read the regulation differently, or are you challenging the regulation?
No, we're relying on CEQ's regulation, which is 40 CFR 1502.9.
So what do I do with the Highway Administration's regulation?
Well, Federal Highways is bound by the CEQ regulations by the Andrus case. I think you have to read.
So if I'm reading this correctly, it's wrong.
Well, it has to be read to be consistent with CEQ's regulation.
Okay,
Yes,
so your bottom line is this is wrong.
And several courts have required supplemental EISs in the case where the alternatives analysis is
Right, I'm just trying to figure out
contemplated.
as a matter of ad law, it does seem to me that in order to come out your way on this point, we would have to be saying this regulation is wrong.
Well, and the CEQ regulations are supreme, Your Honor, yes. With regard to the question of, sorry.
I'll give you a little extra time because I know we've asked a lot of questions, but go over again exactly why the CEQ regulation overrides this regulation. How is it inconsistent?
Well, Your Honor, the CEQ regulation, I think, is just a little bit broader about when a supplemental EIS is required, and the Federal Highways regulation maybe has an extra clause, but I think they can be read.
So what exactly does that I don't have it in front of me. What exactly does that regulation say that bolsters your argument here?
The CEQ regulation, and that this is the regulation which the Supreme Court has interpreted in Marsh, and this court recently interpreted in Save Our Sound, says if there are significant new circumstances or information relevant to environmental concerns and bearing on the proposed action or its impacts. So the point is the information relevant to environmental concerns. And so that's not, there can be a whole variety of things which are relevant to environmental concerns. And I think more broadly, all these regulations have to be read to be consistent with the NEPA statute. And what the NEPA statute is says that NEPA is an action-forcing mechanism which requires both the government and the public to get information at a meaningful time. So in the scheme of NEPA, it wouldn't make any sense to only look at the environmental impacts of a decision you had already made if you hadn't made that decision yet, because the whole point of NEPA is to disclose all that information so you can have a meaningful decision-making process. And I can...
So you've said a number of times that there was a failure to disclose. In the other North Carolina transportation case, it was obvious that the agency entered into a course of conduct to hide information. I haven't seen that here. Are you saying that they intentionally misled the public?
I wouldn't go so far as saying they intentionally misled the public in the same way that they did in the North Carolina Wildlife Federation case, but they certainly say time and time and time again in their FEIS, there will be no reasonable foreseeable impact on the natural resources of the Outer Banks. And we've cited that many times in our brief. And then they say in this sort of backwards way, well, here's the baseline, and then if you build the bridge, there'll be no difference. But if you don't build the bridge, there'll be less development, and you have to kind of dig in to get there, and what the agency should be doing is just saying, if we build the bridge, there'll be this much additional development, and then the key piece is, what impact will that development have on natural resources? And that's the place where the agencies failed here. They just simply didn't do the analysis of what does that additional growth mean for environmental resources. So it's a little bit slightly different, but analogous.
Sure.
I just said, and this sort of, I think, ties together your two arguments, and there's a thing that I am finding just hard to get my hands around. Your theory for why this is sort of environmentally relevant over on the supplemental impact statement is that, look, anything that would tip the balance and get you something that is much less environmentally damaging is relevant. But it does seem to me that in this case, it's not like the original environmental impact statement said this bridge will be very damaging, but we have to do it anyway. It's just so necessary because of the congestion that we have to kind of swallow this very severe environmental impact. As you say, it actually said there aren't going to be any significant environmental impacts with this bridge. And it seemed like it was kind of a draw, at least as between the bridge and the existing roads. And so in light of all of that, this isn't the kind of case where you could say, look, any small change in the benefits and necessity for the project might have flipped the agency over to something substantially less environmentally damaging, because the agency doesn't think this bridge will be environmentally damaging.
Can I make two quick points, Your Honor? I think first, there is a distinction between direct environmental impacts and indirect environmental impacts. They didn't disclose the indirect, but they certainly disclosed that building a 7-mile structure across what is currently a very tranquil sound would have a lot of impact, particularly on duck hunting habitat and waterfowl habitat. I mean, it's a huge structure, so.
No, I understand it's not going to have, but compared to the no-build alternative,
Sure.
It will be more damaging. But this was not the kind of case where the agency says, oh yes, we're going to lose an entire species, but we have to do it. There's no other way to get people out if there's a hurricane. And then it turns out, oh, we found another way to get people out.
Sure, Your Honor. So my second point is that NEPA isn't just about persuading the agency what alternative, that it has to make the least environmentally damaging alternative. It's not about that at all. It's a procedural statute. It's about public disclosure. And what parties like my clients can do with a NEPA document, if it is accurate, is take that and advocate to their local elected officials, to permitting agencies, to the legislature. But if the information they have is outdated or inaccurate, and they've got a picture of the bridge where, well, this other alternative simply won't work because there's too much traffic and population growth is coming too much and the funding only works this way, then they're stymied in their ability to advocate. And that's precisely the purpose of NEPA, is to give this accurate representation of all these different alternatives so that they can then make those arguments in a variety of public spheres. And I'll reserve the remainder of my time, Your Honor.
All right, thank you very much. Ms. Ingalls?
Good morning, and may it please the court. I'm Summer Ingalls for the federal appellees. With me at council table is Mr. Colin Justice for the state of North Carolina. I plan to begin today by explaining why the decision not to supplement the EIS was reasonable with reference to the accurate standards, and then I'll turn to the plaintiff's challenge to the agency's no action alternative analysis. The Federal Highways Regulation, the CEQ regulation, and the relevant case law make clear that supplementation is required only when new information or updated information reflects that there will be a change in the environmental impacts or the concerns, and that change will be significant. Plaintiffs haven't challenged the Federal Highways Regulation, and the Federal Highways Regulation is consistent with the CEQ regulation and also with the Supreme Court's decision in Marsh, which explained that the preparation of an SEIS is required only when new information will affect the quality of the human environment in a significant manner or to a significant extent not already considered.
Ms. Ingalls, I understood your friend on the other side to suggest that because, two things, there'd been a significant delay in the project, and the fact that the project itself had not yet been approved somehow changed the calculus with respect to the government's obligation to prepare a supplemental EIS. Could you speak to that?
No, I'm aware of, well, I can speak to it. I'm aware of no obligation to supplement an EIS simply because time has passed. These projects can take a while, and it's not uncommon for time to pass and new information to become available during that time period. But the fact that new information is available doesn't render the existing EIS inadequate or require supplementation.
Does it matter that the project had not been approved?
I don't think that the fact
I guess
that
it had been approved, but funding had been pulled. Well, you tell me, what
there was
happened?
no ROD or record of decision issued in 2012 when the final EIS was complete. The record of decision came after the reevaluation. But plaintiffs have challenged this as a supplementation issue, and the standards for supplementation are very clear. The fact that the record of decision came later did not mean that the agency's supplementation standards had changed
Well,
or
what was
somehow.
maybe I wasn't following the same wavelength, but I thought what Judge Diaz was asking was, why was the record of decision not done within the 3-year period with the original EIS? And wasn't that related to some funding change or something of that nature?
Yes, and my colleague from North Carolina will better be able to describe the change in funding, but my understanding is that FEIS was completed, the agencies were on track to sign the record of decision, but something within the state's funding structure meant that the project had to be shelved for a period of time. And the Federal Highway Administration's regulations are what prompted the agency to take another look at the information because the 3 years had passed before the ROD was signed. So the record of decision was signed after the agencies completed the reevaluation, determined that none of the updated information would result in significant environmental impacts, and thus that no supplementation was required, and then signed the record of decision.
I understand your opposing colleague to argue that, as one example, that there was updated sea level rise information that the agency did not consider or did not share with the public, or both. So what's your response to that? And is it relevant, and if not, why not?
Well, I disagree with the premise that the agency didn't consider updated sea level rise information. The reevaluation, I point to pages JA 2434 to 35, 2553 to 54, 2563, 2575 to 76. There was a great deal of discussion about this updated sea level rise information. What the agencies ultimately determined was that this information reflected what they already knew from the final environmental impact statement, which was that sea level rise is occurring, it's getting worse. And the fact that the sea levels are rising doesn't implicate the bridge's impacts. If anything, it only reflects the importance of this bridge. Under all of the sea level rise, more extreme scenario, there would be no substantial effect on the bridge.
Supplemental impact statement. Is the district court right that you don't have to do one if the new information doesn't bear directly on the environmental impact of the bridge?
Yes.
That is correct?
I'm sorry, could you restate this?
Yeah, I may be saying it wrong. Does a new EIS have to be done if there is new information? It doesn't bear on the impact of the bridge itself, but it bears on the necessity and the benefits of the bridge so that, the balance might come out differently.
Yes, that is our position based on the
Wait, I'm sorry, which
regulation.
is your position? That it does have?
That supplementation is required when the environmental impacts are implicated and not the wisdom.
So if the state of North Carolina, instead of having a financing package, had approved the bridge, but in their budget it was deficit financed, there was simply a hole, there wasn't enough money in the budgets that's adopted to complete the bridge, and they were going to leave it to the future legislatures to figure that out. If that had transpired, would that have required a reevaluation of the EIS?
If there hadn't been adequate funding and the project had been approved but not proceeded with on the ground, that might be one of the sort of consequential steps required under the Federal Highway Administration's regulations for reevaluation. But without additional facts, I'm unable to say whether it would require a supplemental EIS. I think the question would be if during the passage of time, updated information came to light that bore on the project's impacts in a significant sense, then a supplemental EIS would be required. But a reevaluation would be required if there was a lag between implementation and approval.
Can I just, I'm sorry, I really wrestled with this, so I just had one last question on this. So, I mean, I do read the Highway Administration's regulations that way, but the agency in this case, in fact, did consider in its reevaluation study new information bearing on project need and project benefit. It's like a whole separate section. So does the agency understand, why did the agency do that if it's not necessary?
Well, I think part of the reason it was done here is not because it was required by the regulations relevant to supplementation, but because it was required by the regulation requiring a reevaluation if nothing has happened between approval of the project and the ROD, and that's 23 CFR 771.129.
Gotcha, okay.
And so that the reevaluation encompassed more information than was necessary for the supplementation analysis. But ultimately, the idea that...
I'm sorry, just so I understand, so those are two distinct categories, reevaluation separate from supplementation?
They are distinct in the sense that they are dictated by separate statutes, but here, what the agency did was in its reevaluation, which is required by the regulatory provision I just cited, it looked at whether supplementation was necessary. And in the course of that analysis, it applied the standards for the supplementation regulation.
So was that a NEPA-driven review or a highway statute or regulation-driven review or something else?
The reevaluation was completed because of a federal highways-driven review. Plaintiffs assert that some other test applies that has nothing to do with significance of the environmental impacts. They say that if the utility and viability of the bridge has been questioned, then that would require supplementation. Again, the utility is certainly an important element, but it's not important for purposes of NEPA supplementation. And as Judge Harris noted, the agencies looked at whether this project still made sense and determined that they did. I'd reference here too the DC Circuit's 2017 decision in Friends of the Capitol Crescent Trail. There, the DC Circuit agreed with the Federal Transit Administration that an SEIS was not required to reconsider the utility of a rail project, even though information had come to light suggesting that the project would actually receive less use than was anticipated in the EIS. And the court applied the standard that I've referenced, looking at significance and environmental impacts, and said that because that standard had not been satisfied, no SEIS was necessary, even though there might be some reason to question whether the project was really as important as it had been when the agency completed the EIS. And the court said, even assuming there were some tests that looked at the wisdom, the agency had still satisfied that test because the agency considered data that had come to light about less ridership, and it decided that it would not ultimately change the selection of this alternative. And that's at 1062. So the court didn't change the relevant test. It applied the proper test and then said, even assuming some other test applied, the agencies had satisfied it. And that's exactly what happened here. Plaintiffs also assert that the combined effect of all of the information that had been updated over time implicates the analysis of the best transportation solution. But again, NEPA does not exist to bring into question the wisdom of the ultimate selection. It's focused specifically on environmental impacts, and that's reflected in the standard. I'd also like to turn to plaintiff's suggestion that the agency's no action alternative analysis didn't accurately disclose the relative differences between the activity that would proceed under the bridge alternative and the no action alternative. And here I draw the court's attention to pages 1321 through 38 and 1546 through 50 in the joint appendix, where the court made very clear that there would be more development with the bridge alternative than without the bridge alternative. In fact, there would be a difference of about 2,400 more units with the bridge. And the agencies also identified the effects of that additional development.
Opposing counsel argues that was a consideration that was not evident that the agencies separately did. It's, as best I could understand it, it sort of started at one point and then worked backwards.
Yes.
And there seems to be some contradictory language at different places about what it considered and didn't consider. But I
Yes.
take it the point that the opposing counsel has is they should have started with the no-build alternative and gone forward instead of starting with the build alternative and working backwards.
Correct. But I'm aware of nothing in NEPA or the relevant case law that requires an agency to use a particular approach when identifying the no action alternative baseline. NEPA is concerned with ensuring that the agencies identify relative differences between what will happen if a project proceeds and what will happen if it doesn't. And here the agency said the development baseline is what the project area will look like without constraint. But it was also very clear to say that that baseline would not be met if the project isn't built. And so because the inputs were clear, because the agency explained its rationale and its approach, it's not misleading because the agency not only explained its approach, but also explained in clear figures what the project area would look like on the ground. And the fact that the agency didn't describe development as a direct effect of the bridge was an effort to show that this development is already ongoing, there's demand for it, the area is being built up now without the bridge. So it's ultimately a semantic difference because the record shows that this degree of relative difference was discussed in the FEIS, or in the FEIS. And it's also quite different from the Monroe Connector case, which was decided on very narrow grounds related to disclosure. There, the agency that said that the failure to disclose the data's underlying assumptions and false responses to public concerns meant that the agency hadn't taken a hard look at environmental impacts. But here, the agency was very clear about its analysis. And the fact that it started from the development baseline and worked back from that analysis doesn't mean that the analysis was flawed. I see that I've reached the end of my time. Thank you very much. We ask the court to affirm.
All right, thank you very much, Ms. Ingalls. Mr. Justice?
May it please the court, my name is Colin Justice. I represent North Carolina Department of Transportation and Secretary Boyette. My colleague did a great job, I think, addressing the standards. I wanted to jump straight to one of the questions that the court had asked, and then I'll be happy to answer any other questions. The reason that the agency started with development forecasts that involved an expectation of a bridge is that FHWA regulations direct agencies to take into account local land use plans. Those are done by the Rural Planning Organization from county and city governments. Their plans for growth are based on expectations of what they expect to need for transportation and schools and zoning and things like that. And those local land use plans assume there would be some additional bridge built. So the transportation agency started with that information as the starting point. Then they calculated what the impact of the bridge would be on that growth and subtracted it out. That's the reason that it started with forecasts that assumed a bridge, is because that is what the local planning organizations were using. The environmental documents make it clear and easy for
Your argument is that the federal highway regulations required that particular process?
It's one of the things that agencies are supposed to look at. They're supposed to take into account the local land use plans, and they did. Then they made clear in the environmental documents what the difference was in expected growth between the no build and the build.
So the order was driven by the way in which the land use plans were created?
That's correct.
Is that, I mean, is this particular order unusual, or does it vary from jurisdiction to jurisdiction?
I think it's commonly used because that's the way the purposes for planning are a little different. The local land use plans are planning for a broader variety of needs than just the project that these transportation agencies are looking at. So they use a different starting point, but that's very relevant information for the transportation agencies in planning for the transportation needs. So as I said, those were all disclosed to the public. The traffic forecasts were updated in the 2019 reevaluation. The agencies also updated, took another look at sea level rise, updated financing information, and they looked at whether there were any updates to the impacts. In fact, there were actually reduced impacts in a lot of areas. And another point that I wanted to bring up is that the agencies found that the bridge alternative actually had lower impacts in some areas than the alternative that the plaintiffs prefer, which is to upgrade the existing roads. The bridge had lower impacts on wetland fill, and it had lower impacts for natural upland areas. It also had lower impacts to housing in terms of noise, and lower impacts for displacement of some of the important community features, like there's a mixed-use bike and pedestrian path that runs right along NC-12 that would have been impacted if the road was widened. So the agencies considered all these things. They took a comprehensive, hard look at it, and in the reevaluation concluded that based on FHWA and CEQ regs, a supplement was not required. In the reevaluation, the agencies also considered an additional alternative that was proposed by plaintiffs. Plaintiffs mentioned several times they don't think there was adequate public involvement. As part of the reevaluation process, the agencies met with federal and state regulatory and environmental resource agencies, sought comment, asked them if they thought anything had changed, if there was updated information to consider. They also, plaintiffs received a draft copy of the reevaluation documents, which they extensively commented on. They proposed an additional alternative. The agencies evaluated all those comments and considered them and responded to a lot of the points that the plaintiffs had raised in the reevaluation document.
Counsel, I hope you're the right person to ask. The reevaluation study, is that a public document? Like what is its status as a public document?
It is published when it's completed. In this case, the plaintiffs were given a copy because they frequently make public records requests and are provided with project planning documents throughout the planning process.
But now it is a published public
It
document.
is now a published
Okay.
document.
All right, anything else, Mr. Justice?
No, if the court has no further questions, I would just ask that you reaffirm the district court. Thank you.
All right, thank you. Ms. Hunter, you've got some rebuttal time.
Thank you, Your Honor. Just to that point on the reevaluation, the entire problem for the plaintiffs in this case is that the reevaluation is not the same as a supplemental EIS. It's not public like a supplemental EIS is. It's not public prior to a decision being made, and it's not offered up for notice and comment. And just as a factual matter, when Mr. Justice notes that the plaintiffs in this case got a copy of it, this was a very early draft that we received, I think, over a year before the ultimate reevaluation was published. So, us requesting, the North Carolina Public Records Act is not a substitute for NEPA, and what the plaintiffs in this case wanted was that public democratic decision-making tool of the National Environmental Policy Act where we could review all of the information and comment on it and advocate with it before a final decision had been made. If I can I'll turn briefly to the question of the induced growth, and I just want to clarify that the plaintiff's concern here is not
Say that again, I didn't understand what you said.
the induced growth question. Our concern is not whether this process went backwards or forwards. The Federal Highway Administration can do its analysis in whatever way it wants to. Our concern is that because they did it backwards, what they then did was they just didn't analyze the impact of the growth because it was a negative. And we point this out in our brief repeatedly. They say, quote, no reasonable foreseeable induced development on the Outer Banks. That's at JA 01909. No reasonable foreseeable induced development, JA 01546. And these comments are made throughout the FEIS, that there will be no induced growth and no impact of the bridge in an indirect way. And it's just really hard to square that with their statements elsewhere that there will be 800 additional acres and 2,400 additional units. And so our concern is they can do their analysis however they want to do it, but they need to do it in a way which discloses the impact and then analyzes the impact of that growth on the Outer Banks. And so while it's not exactly like the North Carolina wildlife case, we do believe they misled the public by saying time and time and time and time again, this bridge will have no induced development. And the reason they said that was because they had done their analysis in this backwards way.
There were several passages where they talked about 68 acres of development at the entrance to the bridge or something like that. Is that correct or incorrect?
Well, that's on the mainland, Your Honor, not on the Outer Banks, first of all. And while there is somewhere this sort of backwards acknowledgement, my friend over here stated a few times, it's very clear. It's not very clear. There is at one point an acknowledgement of this 800 acres.
So is the development that would occur on the mainland side not relevant?
Oh, that's relevant, but it doesn't absolve the agencies of their duty to analyze the impact on the Outer Banks. And I think we go through at length in our reply the places where they have pointed to where they said they did this analysis. And I think if you just take a look at the record, it's quite clear that they just didn't do it. And that's our concern. In the last couple of minutes, if I can talk again about the supplemental EIS standard, there is no court which has adopted, other than Judge Flanagan, which has adopted this idea that the alternatives analysis and the balancing of different environmental impacts of different alternatives is irrelevant to the SEIS inquiry. In fact, this court in Save Our Sound did that inquiry. It looked at the balance of alternatives. The case cited by my friend here speaks to that inquiry. It says, assuming that NEPA requires an SEIS where new information justifies reconsideration of a more environmentally favorable alternative, on this record, the situation didn't pass muster. But that test is the correct test. And the Ninth Circuit, the DC Circuit, the Fifth Circuit, this circuit have all made that inquiry. And that's because that's what NEPA is all about. NEPA is about helping make good decisions.
Can I just go back to the question I asked you before, and I may not be framing it right, but I really was sort of combing your brief for the part where you would say, and that's why when you take this information into account, this other substantially less environmentally damaging alternative would be the obvious choice. I don't even understand are you suggesting that this information is significant, the traffic information and things like that are significant because it would have led the agency to choose the no-build alternative or the existing roads alternative? I don't even know. I just feel like half your argument hasn't been made here.
Well, I think we didn't make that argument because NEPA is not a substantive statute. That might be more appropriate to make in a wetlands 404 case. But yes, the agencies...
That's their entire argument, right? So why does it matter? Because as you say, NEPA is not a substantive statute. What it's for is disclosing the environmental impact of the bridge, and that hasn't changed except that it's become more modest.
And what NEPA is for is it's the heart of the environmental impact statement, as the regulations say, is the alternatives analysis. And this bridge was selected because it was the only alternative that could solve these dire traffic needs.
Since it's not in your brief, just tell me, in your view, this new information is environmentally relevant because it could have reasonably persuaded the agency to choose X alternative, which would be substantially less environmentally damaging.
A variation on the existing roads alternative
The
is
existing roads
is the
alternative.
alternative that the plaintiff submitted, yes.
Okay, so if I think that in reading the original environmental impact statement, it's not clear to me that the agency, that it seemed like it was a draw on environmental impact. There were things that were better for the environment about the existing roads alternative and things that were worse for the environment about the existing roads alternative. So how,
So
what do I
you're-
do with that?
I think the crux of this matter is, do we want to spend $600 million on a new bridge to the Outer Banks? And in 2012, the agency said, yes, because traffic's going to be so horrendous, because growth is coming so much, because it's the most cost-effective thing to do, and because even though sea levels are rising, it's not going to interfere with this bridge. Now, you fast forward 7 years, and every single one of those factors has changed. The traffic projections are half what they used to be. The financial situation is completely different. The sea level rise is coming at a much faster rate, which makes a new bridge to a barrier island a less good idea. And so you've got a completely new picture, and it's not just about whether you can persuade these agencies to do something, but NEPA is a tool for democratic decision-making.
Right, and so in your perfect world, now instead, they will do the existing road alternative, which has also negative environmental consequences, which seem to be sort of on a par with the consequences of the bridge. So I guess I'm still not understanding how you get to sort of the environmental relevance.
We do not believe that the existing roads alternatives has the same environmental impact as the bridge, particularly because a lot of our clients are duck hunters. They spend a lot of time in the Sound, and a whole new bridge through that Sound is a very different question. If I could make one last point, Your Honor, even if you wanted to focus only on environmental concerns, the idea that sea level rise, which has changed so significantly, and for opposing counsel here to say, well, we just confirm what we already knew, that sea level is rising, is kind of missing the point. Sea level is rising at a much, much faster rate than it was in 2012, and that absolutely has consequence for a decision about whether you build a new bridge, whether you spend $600 million of North Carolinians' money on a new bridge to a barrier island. And so that issue of sea level rise is something which should have been disclosed to the public, and the fact that the agencies looked at it somewhat themselves but did not make that information public is a violation of NEPA.
All right.
And with that, I would ask you to vacate the record of decision. Thank you, Your Honor.
Thank you very much. As you know from past practice, we would ordinarily come down and greet counsel in the well of the court, but our COVID restrictions don't let us do that now. So we wish you the best, and thank you very much for your arguments. And I'll ask the clerk to adjourn court.
This honorable court stands adjourned, signed, die. God save the United States and this honorable court.